A very warm welcome to everyone. Today, I, KHANNA, a legal intern under LEXIS and Company, am here to explain my topic Nemo, Moriturus, Praesumitur, Mentire. A person who is about to die would not lie. The concept of dying declaration is based on this legal maxim Nemo, Moriturus, Praesumitur, Mentire, which means no one at the point of death is presumed to lie. Dying declaration is the statement which is made by the person who is on the deathbed and can anytime be called dead. In Section 32, Clause 1 of the Evidence Act, the only statement that is given just before the death is dying declaration. Also, the statement that is given before and which explains the cause of death is also a dying declaration. A person who is conscious and knows that the death is about to happen and can make a statement about the reason of his or her death, which will be admissible in the court. The word dying declaration explains the word itself. It means a written or a verbal statement of relevant facts made by a person who is about to die or is dead. It is the statement of a person who knew the cause of his death or the circumstances of his death. It is said that a man will not meet his maker with lying on his mouth. In our Indian law, it is a fact and it is believed that a dying man can never lie, or truth sits upon the lips of a dying man. Admissibility of dying declaration. Since the dying declarations is the last testimony given, but in any form it cannot be considered as admissible in the eyes of law, but it is the functioning as a piece of evidence with the proper identifications of dying declaration. In a case, the apex court also held that the crux of the whole matter was as to who had stabbed the deceased and why. These crucial facts are to be found in the dying declaration. Types of dying declaration. Number 1. Question answer form. Where the dying declaration was not recorded in question answer form, it was held that it could not be discarded for this reason alone. A statement recorded in the narrative may be more natural because it may give the version of the incident as perceived by the victim. Number 2. Gestures and sign form. In this, let's take the example from the famous case of Queen Empress versus Abdullah. In this particular case, the accused had cut the throat of the deceased girl, and because of that, she was not able to speak. So, she indicated the name of the accused by giving the signs of her hand and signal plays the role to reach the victim. It was held by the full bench of Allahabad High Court that if the injured person is unable to speak, he can make dying declarations by sign and gesture in response to the question. In another case, the apex court had observed that the value of sign language would depend upon as to who recorded the signs, what gestures and nods were made, what were the questions asked, and whether simple or complicated, and how effective and understandable the nods and the gestures were. Number 3. FIR as a dying declaration. In the case of K. Ramachand Reddy versus Public Prosecutor, it was held that where an injured person lodged an FIR and then died, it was held to be relevant as a dying declaration. Certain points to be remembered while recording dying declaration are: number 1, it should be clear that the dying declaration can be recorded in any language. Number 2, if the testimony is recorded in some other language, then the magistrate who recorded the testimony should be on record and proper precautions should be taken. Number 3, the court cannot reject the dying declaration on the sole ground of language, as in the court cannot deny the testimony if it's in some other language. Number 4, in the case of Pijun Joseph versus State of Kerala, it was held by the court that merely on the ground that the statement of deceased was in her own language cannot violate the dying declaration. It was stated by the High Court of Kerala that, assuming that the deceased gave her statement in her own language, the dying declaration would not violate merely because it was recorded in a different language. We bear in mind that it is not unusual that courts record evidence in the language of the court, or even when witnesses depose in their own language. Judicial officers are used to the practice of translating the statement from language of party to the language of court. Such translation process would not upset either the admissibility of the statement or its reliability. Now, who can record dying declarations? Dying testimony is recorded by the magistrate is best of all. If the condition of victim is getting worse and there is no time left to call the magistrate, then any public servant present at that particular time can record the testimony. Number three, it is wrong to say that the testimony recorded by the police is always invalid. And number four, if the testimony is recorded by someone else who is not as competent as the magistrate, then the signature of all the witness should be taken after the testimony is being recorded. Whosoever were present that time during the recording of testimony is considered as the witness. Now, this is all that we are going to talk today about dying declaration. In the next video, we shall be understanding the meaning of the Latin maxim, and certain case laws will be followed. Thank you.